Welcome to This Week in Correctional Institutions. This week, our focus will lie in talking about the death penalty, capital punishment, what it entails, and talking about the inmate's experience while living on death row. So what we'll cover during this particular lecture will be to look at the public opinion concerning the death penalty. We'll compare the importance of the aggravation versus mitigation that is considered during the death penalty phase. We'll discuss the position of the Supreme Court in several of their decisions around the death penalty. We'll look at the position of the Supreme Court while we discuss several of the factors around race and other important issues when it comes to talking about the death penalty. We'll talk about how you as correctional officers who might decide to work for a Department of Corrections that actually has capital punishment still on their books, how it affects you working on death row. We'll talk about the inmates and how they adjust to the situation of being on death row. And then we'll evaluate and talk about how research over the years looks at and whether it actually does, based on research, deter murder. So we've got some things to talk about, but let's start with the first thing, which is to look at the idea behind capital punishment as a sentence. When we look at capital punishment or the death penalty, what we're doing is recognizing that it is the ultimate in sentencing dispositions that can be handed out by a court when a defendant has been found guilty of the most serious of crimes that have been identified by the society as well as legislatures or lawmakers throughout the United States. It's something that has been talked about, has been argued, debated, researched since the inception of the United States as a country, and something that continues to be argued in political arenas and society even to the 21st century. One of the many opponents to the death penalty was the Quakers, and it is their stand that taking a life for the taking of a life was not considered to be an equal punishment and was considered to be contrary to the development of a happy and fruitful society. But for every argument, such as those that were brought forth by the Quakers, you had those who believed, in contrast, similar to what had been part of our society since the inception of punishment, going back 3,000 years, as we had discussed, going back to the very beginning of this semester with the history. And many still hold that position, believing that capital punishment was a severe deterrent and that it could keep people from committing crimes if they knew that there was the severest of punishments hanging over their head, and therefore it should stay on the books. What is reality as we enter into the 21st century is capital punishment as the ultimate sanction for those who commit crimes is now been abandoned by all but 6 states here in the United States. And while it still may be on the books, in actuality and in practice, it's not being carried out as much as it used to be, and with not as much fervor as in our past history. The statistics that have been available only go back about 4 years, and only about 30 executions took place in 2015. And while you could do your own research and see if there have been any higher than that over the last couple of years, what we're seeing is a steadying off of the use of capital punishment as a continued sanction, while we still have juries that have that option. What we're finding and what we'll talk about as we continue on through this particular chapter is that while it is still an option, it's being used less and less, and those that are given the death penalty as their punishment are going to be those that are going to be considered the worst of the worst. And then we'll talk about why that is and the process that they continue to go through. In looking at the death penalty in today's society, what we're looking at is a progression of how the executions are meted out. And if you remember back to the chapter in your Introduction to Corrections class, what you find is when capital punishment was the predominant way of carrying out any sort of punishment, so we're talking going back to the beginnings of crime and punishment, and then progressing through to the modern day, there were a wide variety of ways that governments and monarchies and civilizations would carry out this particular type of sanction. As we get into the modern day and we find how governments and how states and jurisdictions would carry out capital punishment, what we find is as we get into a higher civilization and a higher way of thinking, the idea was that if capital punishment was necessary, then you were going to find a way that would be the most humane. And we'll talk about the Supreme Court and their role in this, but if you compare capital punishment and how it was carried out centuries ago as compared to today, you'll find that the brutality of it is not necessarily as intense as it was years ago. Predominantly, when we were a young country, most of the capital punishments were carried out either by hanging or by firing squad. You've got your infamous burning at the stakes, which was done infrequently but was still done. As we moved into a more technological industrial age, what we find is it was considered to be more humane to use the new inventions such as electricity. And so part of the Battle of the Currents in the late 19th century fought over and tried to prove that alternating current was more dangerous than direct current, and therefore using current at all to take a human life was starting to be utilized as a way to take a human life, and considered to be more humane because it would be quicker. There was a brief movement into the use of the gas chamber, but with the advent of World War II and the realization that Nazi Germany and the use of the death camps used gas, that was discontinued for a while, so that that did not look like we were attempting to be like the Germans at that time. So very few states have the gas chamber as an alternate. By the late 1970s, there was a push to use a drug cocktail, and that is predominantly what we use now, which is lethal injection, as it is a way to be as painless, according to the people who are defendants of this type of execution. But even with lethal injection and the issues that have arisen from the last several years with the drugs availability that have been used previously and the workarounds that some states have tried to find to make up for the shortages in the drugs that had been used, finding that what has been in practice is now not necessarily what has shown as maybe a less humane way. So we still have lethal injection as the predominant method of execution, but keep in mind that if the shortages are there or the inmate themselves would like to use an alternate form of execution, then each state has to have a backup or a second type, and every state then has a alternate form, either electric chair, hanging, gas chamber. We have a couple of states that have the firing squad that's available to them, and therefore if lethal injection either is unavailable or is not able, the inmate chooses not to have that particular form of execution to be used, there are avenues that allows the alternate form of execution to be used. With the opinions on the use of the death penalty still being gathered over the years, we show that over the period of the late 20th century, early 21st century, the American public opinion has shifted to not necessarily always behind the death penalty. And while they still support the option of having the death penalty, when they are given the choice between life without the possibility of parole or the death penalty, most Americans in today's society in the 21st century will choose life without parole. And that has shown a drastic shift in public opinion on just where the death penalty is nowadays. They support the death penalty, but if there is an option to give life without parole, then you see a significant downturn in the use of, or the option of, giving out the death penalty as the ultimate sentence. And so what we're seeing is a society that when there is a choice, they're choosing life without parole. It has always been part of society to support the death penalty, and that of course then drives our politics. And with that, we still see many of our political forums, a lot of our political stands, especially in election years, to either show support or have one of their platforms take a stand as part of their crime control platforms to either take a solid stand for the death penalty or against the death penalty. And historically, the Republican Party tends to be a more crime control type of party when it comes to their platforms, and typically will more support the death penalty and severe punishments. And that will drive a lot of whether or not states will continue to offer the death penalty as part of their sentencing guidelines or sentencing options. In recent political years, crime control has not really included the death penalty a whole lot. They have been concentrating more on sentencing options and restructuring. Some have been concentrating more on reform. And so the death penalty really has not been part of the most recent political platforms, but it still hangs around. What we have seen is any political comments have been at the state level and less at the federal level, which is why we see more and more states that, while they keep it on the books, you have seen less and less use of it. And over the last decade or so, you've seen a lot of state governments decide to either put a moratorium on their death penalty, or you have seen them completely take it off the books, state by state. And so we've seen, whereas 25 years ago there were 30 plus states that had the death penalty as part of their sentencing structure, you now have less than 20 that actually have it still as part of their sentencing structure and actively use it. When we look at the profiles of most death row inmates, you will find that while we will talk about the issue of race more extensively in later slides, the profiles that you will find is they are Southern white males in their 40s. We will touch briefly on the female inmates in a little bit, but not very many women are on death row. They are a very small percentage. There are only 16 or so women who have been executed since the death penalty was reinstated back in 1976. But some of the other commonalities that they have, and we have talked about this many times over the course of this semester, they are intellectually, they have very low IQs, almost to the point where they are functionally illiterate. They are academically lower than most people in society, which means they are most likely not high school graduates or have not finished predominantly into secondary education. Also, part of their history is that they came from very dysfunctional families with a history of either physical or emotional abuse, sometimes sexual abuse. Their families were part of very risky behavior, mothers who were drug addicts, prostitutes. They themselves suffered from substance abuse, and therefore what we find are a high percentage of those on death row are suffering or have suffered from developmental issues as they came through the system. And so what we're dealing with is the issues of the profiles are not necessarily what we expected, but what we're working with is those inmates that are currently on death row have a high rate of disorders, psychological issues that will only increase with their time on death row. And so as we continue on within this particular lecture, you have those inmates who are already mentally ill and then come to death row, their psychological illnesses will increase, and we'll talk about that in just a little bit. Those that might come on to death row and might not have the diagnosis yet are more prone to develop a psychological disorder once they come to death row. And so we've got a couple of dynamics that are specific to those inmates who spend a significant amount of time on death row. I think some of the greatest information that we can take away from some of the early part of the readings is, number one, just how much public opinion has changed, but political support remains pretty steady. And a lot of the public opinion has changed over the years because of the importance and the changes that have come, and mostly that has been due by the use and exoneration of inmates based on the DNA evidence that has started to enter the arena. Now, DNA started to become a predominant tool to show wrongful convictions and innocence back in the early to mid 90s. And over the time, in the last 20, almost 30 years, 25, 30 years, what we have shown is that eyewitness testimony and other types of investigative procedures, while not done maliciously, although I can't excuse some of the types of investigations that have been uncovered over the years, DNA has become a tool to show that some of the investigations and personnel were not thorough in how things were handled, and therefore were erroneous in sending people to their supposed death. And so what happens when you have this type of tool that through science has become almost irrefutable? And I'm not saying it's totally irrefutable. What I'm saying is it has become a tool that shows an error that is hard to look past. And with that, showing the system as needing other avenues to show guilt or innocence than some of the previous types of investigative techniques that had been used and abused in several areas. And so with this, public opinion and political support has changed in a way that has shown a need for some alterations. And there's a complexity to it that requires a need for a reevaluation. But when you look at how the international community really looks at the use of the death penalty, the United States is one of a handful of civilized nations that still use the death penalty as the ultimate form of punishment. And when you look at the other countries who continue to use the death penalty, you put us in a category with countries that are considered to be third world and not as civilized or technologically sound as we are. And so if you look at this slide, you're talking about countries like Iran, Pakistan, Saudi Arabia, and then a lot of countries in Africa and Asia, and you look to see whether us as a country really should reevaluate whether it is something that is desperately needed in our country. The other thing is, because of our stand on the death penalty, is one of the main reasons why the drugs for the lethal injection have ceased to be available. They are compound drugs, and the drug manufacturers that we were relying on for so long were being manufactured in countries that had discontinued the death penalty. And they had come out and stated that they would not continue to manufacture the drugs if they knew that they were going to be used for the sole purpose of lethal injection. And so that also started to create a conversation of whether it was a necessary part of our justice system. And I'm not saying that it is or it isn't. I'm just putting it out there that this is what the United States has been dealing with for the past decade or so. We also have to take into consideration what the death penalty appeals look like. When somebody is convicted of a capital crime, which is what makes them eligible for a sentence of death, they start to enter a phase which is the determining factor of whether they will then be given the death penalty as their punishment. Once this happens, then they are given the opportunity to go through a very lengthy and costly appeals process that happens not only in the state courts, but then in the federal court and the federal appeals court. And so if you remember from your law classes and government classes in high school, we have a dual court system, which basically, if you look at it, it is the state courts on one side, federal courts on the other, and while they are separate, they look fairly equal. And so you have somebody who is convicted of a capital offense in a state that has the death penalty. They have been convicted in a circuit court. And so from there, they are allowed to then appeal their conviction and their sentence to that state's court of appeals. From there, they're going to, if they don't get a favorable decision, they get to appeal it to the state Supreme Court. And then from there, if they don't get a favorable decision, they get to start with constitutional questions at the federal court level. And so they go to the circuit court, the federal circuit court, and then the federal circuit court of appeals, the federal. And so this is a process that takes many years. It's going to take lawyers' fees, lawyers' time. And what you're looking at is a complex process that, depending on the state, allows anywhere from 4 to 11 appeals in a process that can take anywhere from 15 to 20 years. And with that process in place, the average length of stay for a person on death row is 17-ish years. So you get somebody who is on death row and they get sentenced to death row. They're waiting through this appeals process for, on average, almost 20 years. And the story that I always like to tell, and I probably tell it in every lecture that I talk about the death penalty, is if you look up one of the most prolific serial killers that we have, California had one called the Night Stalker. His name was Richard Ramirez, and he was convicted in 1989 of a series of stranglings throughout the California area. And he was sentenced to death because he was a serial killer. I don't have a problem with that. And he died in 2004, not by execution, but by natural causes. 25 years he had lived on death row, and he died of natural causes because he had not exhausted his appeals and he had not been given an execution date. And what we'll talk about as we continue on through this process is not only the effect that it has on the inmate, but the officers, and then the corrections system as a whole, both economically and then as in other areas as well. When we talk about the process that people have to go through, what we talk about is a two-stage process at the court level. And they have a guilt or innocence phase, which happens at the trial. Somebody is charged with a capital offense, which is usually murder, kidnapping, rape, anything like that, that requires the possibility that they can be charged, and the sentence could include a sentence of death. And this is something that is decided when the prosecutor files charges. And at that point, if the prosecutor decides that they are going to seek the death penalty as a sentencing option, then you are immediately going to have a two-pronged trial process. And the first part is the guilt or innocence phase. So you have a part of the trial where the jury is going to determine, number one, whether the person is guilty or innocent. And with that, once it is determined that they are guilty, then you immediately go into the second phase. And this is where the jury then decides whether the person is going to be sentenced to death or whether they are going to be given the other available punishment, which typically is going to be life in prison without parole. And it's because of this that we have a two-phase process. Now, the reason that this came into being will be explained in future slides, but this is basically how we start the process when we're dealing with death penalty cases. It was back in the late 60s that we had some major questions as to the constitutionality of the death penalty. And the constitutionality of it still comes up every now and then. And we had some major decisions, even up to, I think, the last major decision regarding the death penalty in certain individuals as late as 2008. And we'll talk about that as we move forward. But the first major decision that had to be decided, and when we're talking about the constitutionality, we are dealing with the Eighth Amendment, protection against cruel and unusual punishment. And so one of the first questions against this was decided in 1972 with Furman v. Georgia. Now, one of the things that was being brought to light with this particular question was the arbitrary and capricious use of the death penalty, specifically against minorities. And the biggest question that came up during that case is that it was being disproportionately used against African Americans, and the Supreme Court, in a 5-4 decision, relied on not only the 14th Amendment Equal Protection Clause, but what they had come out and said is that due to the fact that there was an Equal Protection Clause in the 14th Amendment, which meant that everybody needed to be treated equal, that the legislatures of all 50 states needed to write laws that were even-handed, non-selective, non-arbitrary. And therefore, what needed to happen was that all states had to have in place laws that did not have so much what they considered to be discretionary freedom that allowed judges to impose the death penalty on what were considered to be a select group of people. In this case, and what was being proven, was that poor, unpopular racial minorities were the people that were being sought out for the death penalty. And so with that started the roller coaster of what did the states now have to do. And the discretion that was being used, the Supreme Court said, yeah, you're not going to be able to be that discretionary, because there had been a pattern that was being shown. And you have to remember that this was right in the middle of the Civil Rights era and Jim Crow. And so showing the Supreme Court at that time that there was arbitrary and capricious use of the death penalty against a specific group of people was landmark, and it was extraordinary for the time. And so therefore what we have is the beginning of a huge change. They didn't completely rule out the use of capital punishment, but what they did say is, come to us when you have started to rewrite your laws and show that you have a way to be more equitable, and you have a way to show more fairness in giving out the death penalty. And so for 4 years, there was no death penalty. So in 1972, this decision came out. And so what happened? With Furman v. Georgia, every single person on death row had their sentence commuted to life in prison without parole. One of the main reasons Charles Manson ended up spending his entire life in a California state prison. He had originally been sentenced to death for his role as the ringleader in the Sharon Tate murders. But because the decision in Furman came out, everybody who was on death row had their sentences commuted to life without parole. And all of a sudden, you had a bunch of people awaiting death row, execution. Done. Now they had their sentences commuted. 4 years later, the Supreme Court came back in another Georgia case, this one being Gregg v. Georgia. And this is where you had your determination of what they call a bifurcated trial, or a two-pronged trial. And you had the guilt or innocence phase, where you had to find somebody guilty. And then you had to have that same jury decide between the death penalty or life. And so it's at this point where you have the idea behind a couple of different things. And this is where we start to get into the difference between aggravating and mitigating, and we'll talk about that in a later slide. The other big cases that came out that are dealing with the legality of the death penalty came in 1984 with Pulley v. Harris. And this challenged the California law because it did not require the sentencing court to compare the facts of the case with the disposition of other cases. And the Supreme Court sided with California because there were special circumstances where the death penalty could be imposed that were above and beyond other types. So, for instance, special circumstances for murder. If you had a murder for profit, murder perpetrated by an explosion, murder of a police officer, these were going to be special circumstances where you could seek out the death penalty. And therefore, they were figuring out where the eligibility for execution was. And then Kansas v. Marsh in 2006, the Supreme Court ruled that the death penalty scheme in Kansas ruled that when you have the imposition of death penalty when mitigating factors stand equal with aggravating factors. So when we talk about aggravating and mitigating factors in just a little bit, keep in mind Kansas, when they're equal, when you have 2 mitigating factors and 2 aggravating factors, and the jury decides still to go with the death penalty, the Supreme Court said, yeah, that's okay. And so they were looking for a little bit of clarification just how much weight you should be giving mitigating and aggravating circumstances. So those are some of the major type of Supreme Court weighing in on exactly what we need to be looking at when we're talking about constitutional issues with the death penalty. So when we talk about actually the death penalty period, what we're talking about is how the court decides. And again, when the prosecution chooses to seek out the death penalty as part of the case itself, so number 1, it's got to be a capital case. Number 2, the prosecution has to decide that they're seeking that as a sentencing option. And so if the prosecution decides they're not even going to put capital punishment as a sentencing option, then we don't have to worry about it. So when the prosecution then decides they are going to seek the death penalty as a sentencing option, there's a lot of things that need to be employed when it comes to how the death penalty works. The court is going to be informed of the defendant's background and criminal history. Why is that important? Well, if you go back to the slide that we talked about, those that are actually on death row, regardless of the fact that a higher percentage of them are Southern white males, many of the people who are on death row have a literacy issue, they have an educational issue, and they come from traumatic backgrounds with psychological disorders. And so that is, according to the court, a very important part of why the court needs to be informed. Is it going to excuse them? No. But when you look at the next bullet point on the slide, mitigating factors are going to be disclosed. And these mitigating factors might affect what's known as their culpability. And so when we look at mitigating factors against aggravating factors are going to be those issues that might lessen the culpability or how much blame the defendant is going to take in the case. And aggravating factors are going to be those issues that are going to increase the amount of blame that the defendant needs to take in the case. And so the mitigating factors are going to be those that are going to be disclosed to the court. Things like they are functionally illiterate, so they can't read above the 3rd grade level, they can't do math above the 8th grade level, they never graduated high school, therefore they were never able to hold down a job, they suffered from emotional and psychological abuse, they currently suffer from whatever disorder. Those are mitigating factors. Will it excuse the crime? No. Will it be a factor in determining whether they are going to be executed? Yes. And so those are some of the things that need to be available to the court in the long run when it comes to determining the sentence between execution and life in prison without parole. So when we're discussing mitigating factors, we're not discussing letting them get away with the crime. We're discussing whether there are things that should be considered that would take away the ultimate punishment, which is that you execute them. When you're looking at aggravating factors, are you looking at the fact that, like with serial killers, there are multiple victims over the span of several years? Are you looking at the death or sadistic death of a child? Things like that. Those are going to be things that are going to increase the culpability. But you also are going to have strict standards during the trial process and sentencing. So there are going to be in place things that the court needs to follow. All death sentences are going to be reviewed by the state appellate court to make sure that the processes that were in place were followed according to what has been laid out. And if there was an error, then it can be rectified at the appellate court level. And so those are some of the things that we need to keep in mind, is that there are ways to ensure that if somebody is being sentenced to death, hopefully there were no errors that were done. And we mentioned in an earlier slide that what might become a little bit of a surprise is that there's a higher percentage of white males on death row than there are any other race. But that doesn't mean that we don't have an issue when it comes to the racial makeup of those who are on death row. And so there has been a rather lengthy history of how the disparities between race and ethnicity has been handled when it comes to the death penalty and how it has been meted out. There's been several Supreme Court decisions that have dealt, besides Furman v. Georgia, with the disparity and disproportionality of which the death penalty has been used against minorities. But there's also been a few things that need to be discussed when it comes to how the death penalty is used against minorities in certain categories. And so that's what we're going to talk about on this particular slide, and the Supreme Court cases that clarified some of the racial questions regarding the use of the death penalty. In 1987, the Supreme Court decided in McCleskey v. Kemp that there was no racial bias when it came to the sentencing of Mr. McCleskey. Now, the thing that he was bringing up is he had been convicted of killing a white police officer. And so his question was that there was disproportionate sentencing of all African Americans to the death penalty. And what the Supreme Court said is you can't bring about that type of question unless you can prove that it was specific in your case, and in which case it wasn't. So there had to be evidence that in his case specifically there was racial bias. And because he couldn't prove that it was specific to him, it was only in general terms, then the Supreme Court said there was no racial bias. And so that was one instance where the Supreme Court was basically siding with, well, there might be racial bias, but there wasn't in your case, and so therefore we're not going to say that there was blanket racial bias across the board. The other thing that came out of it was that in 2003 there was an African American defendant in Miller L. v. Cockrell that had been convicted of capital murder, and the Supreme Court actually came back and said that they had wrongly, the prosecutors had used all of the peremptory challenges to eliminate every possible African American from the jury. So there was no way that he was going to be tried by a jury of his peers because they had tainted the jury pool by racial bias. And so they also noted that the court the prosecution used underhanded techniques to eliminate a lot of African Americans, and therefore they came back and said jury selection cannot be tainted by racial bias, which basically means that there now has to be in place ways that in voir dire, which is the jury selection, there's got to be processes in place where these things can be taken care of. If we're looking to see whether there is a racial effect when it comes to race and the death penalty, the answer is, kinda. If you look strictly at the percentages, then we're looking at more whites than blacks are on death row. But if you delve a little deeper and you figure out under what circumstances the races are sent, then you're going to find out that more African Americans are sent to prison and to the death row when their victims are of a different race. So it's all in how the research is done. It's all in how you study. So while you can say, well, there's more whites than blacks on death row, it technically is true, but then you have to kind of delve in and you have to look at the geographic locations. You have to look at the race of the defendants versus the race of the victims. And so it's not a black and white type of research and question. You have to be willing to look a little deeper into what exactly you're looking for. And so when you look at those types of numbers, you are going to see disproportionality. And you are going to see that in states that still have the death penalty, there is going to be inequity and there is going to be disproportionality. And there needs to be further academic scrutiny to determine whether there are racial biases that are entrenched within some state systems, especially those that have the death penalty as their ultimate type of punishment. So now we're going to talk about those inmates who are actually protected from execution. So over the years, we have had cases come before the Supreme Court that have questioned the legality of somebody who has been sentenced to death and the appropriateness of them having that sentence carried out. And so the first two have to do with either the mentally retarded or the mentally ill. And these have all been fairly recent, so we're talking within the last 30 years. So if you can consider the Supreme Court weighing in that before that, if you were mentally ill or mentally retarded, mentally handicapped, that didn't excuse you from being put to death. But in 2002, the Supreme Court decided in Atkins v. Virginia that execution of a mentally retarded individual was unconstitutional. Now, here's wherein we have an issue. What constitutes mentally handicapped? In this case, this was not. This was kind of a no-brainer because Mr. Atkins had an IQ of 49, so that puts him pretty low on the bar. But when you're looking about criminal responsibility as far as mentally handicapped individuals, the courts have really set that bar at 70. So if you have an IQ of 70 or above, you can be held criminally responsible, and therefore, technically, you could be also sentenced to death. In the case of Atkins v. Virginia, Atkins had an IQ of 49, which basically put him in a category where if you have an IQ of below 70, then you are not going to be held responsible. Does it mean you can't be held in jail? He killed somebody, so yeah, he was going to be kept in prison, but he could not be killed for it. When it comes to mental illness, what the Supreme Court said in Ford v. Wainwright was that in order for a mentally ill person to be executed, they need to understand, number one, that they've been sentenced to death, and number two, why, the reason behind it. If they were unable to comprehend those two things, then the execution was unconstitutional. And so that was a pretty significant breakthrough, in that mentally ill before then, they were being sentenced to death and it being carried out, even though a lot of them were not understanding why it was happening. In Thompson v. Oklahoma, this was the first of many that had to deal with the juvenile population. And so this one was the first one that dealt with juveniles under the age of 16. And this only came out in 1988. And so in 88, the Supreme Court decided that the 8th and 14th Amendments, so cruel and unusual punishment and equal protection, did not allow any state to execute a juvenile under the age of 16. Clarified a year later, they did say that you could execute a 17-year-old in Sanford v. Kentucky. And then you fast forward to 2005, and the Supreme Court came out that year and put the entire question to rest by saying that you cannot execute juveniles who committed a capital crime under the age of 18. So what we're doing is now we're clarifying, and the Supreme Court said, because they understand that the appeals process takes anywhere from 15 to 20 years, depending. And so you got somebody who commits their crime as a juvenile at 16, 17 years old, fine. We have two previous court cases that have dealt with that. But somebody who is arrested, convicted at 16 or 17 years old, they're not going to be executed until 36, 37 years old. So the way that the courts are looking at it is, we're not going to execute a 16 or 17-year-old. We're committing somebody who committed that crime at that age. And in Roper v. Simmons, the Supreme Court went, listen, if they committed the crime under the age of 18, you're not going to be able to execute them. It's not, they are of an age where, and we've talked about this in other classes, they do not have the mental capacity or maturity to understand the consequences. Does that mean they get away with it? No. They will probably still spend their life in prison, although there have been subsequent Supreme Court decisions that have dealt with that. But as far as the death penalty is concerned, there is no provision to now execute a juvenile who had committed their crime when they were under the age of 18. So now we're going to take a look at some administrative issues, and if you live in a state that has the death penalty as a sentencing option, that means you have the responsibility as a court to be aware of putting together what is known as a death-qualified jury, which means in these two Supreme Court cases, you cannot have any person on your jury who is opposed to the death penalty, and that they must be removed during the voir dire. And with that means that you will not have anybody in the sentencing phase who will deadlock on sentencing to death. And so that is one of the administrative issues that need to be kept in mind. So now we're going to talk about being an officer, and then followed by inmates who are living on death row. Those states that still have death rows, their conditions pretty much vary depending. For the most part, because it's considered to be highly maximum security, everything is brought to the inmate. Meals, how they receive their rec time, what they can and cannot order to help pass the time. Some will allow televisions and radio, some may not. What access they have to see the outside or to have airflow, it's just all going to depend on the Department of Corrections and what they have decided is appropriate for their maximum security death row inmates. Visitation, as far as family visits, is going to vary. Attorneys are pretty much given unlimited access except for weekends, only because chances are they're going to be trying to put together appeals and motions and briefs, and so having the attorney's access to these inmates is something that is a consistent as far as they are considered. So with the inmates, they have a lot of isolation time on death row. They don't see their families very often, but they see their attorneys a lot. What they are allowed depends, but the idea is that they are alone in their cells all but maybe 1 hour a day or so, in order to keep them completely isolated from anybody else within the facility. Most inmates who are on death row, they don't and are not executed at the same institution where death row is located. It just depends. So prior to their execution, they will be sent to another facility. Those who are responsible for security and safety of those on death row are considered a specialized group of officers. And so these officers are a special group. They develop relationships and a lot of times will develop a rapport, remembering that these inmates are in this particular area anywhere from 15 to 20 years. So these officers will spend almost their entire careers with these inmates, and so it's not improbable, and it's almost expected that you are going to develop a rapport and a relationship with the inmates on death row. And so part of what a lot of people don't understand is when inmates and officers in this one area who are pretty much isolated, just them, when an inmate goes to the execution chamber, it's going to be very common for that officer to feel a sense of loss and feel that they have, even though they've done their job and they're not responsible for the execution, that they have lost an inmate that they had a good rapport with, and that's normal. And so it's not, we should be able to try and empathize and understand and not criticize officers who actually have that type of feeling. For those inmates who are transferred to the facility where the execution is going to take place, Usually you are going to have a death watch that is anywhere from 1 to 2 days prior to the execution. And during this time, you will have an execution team that is drawn together. And these are going to be a supervisor that makes sure everything is done correctly and that the team puts together the job that they are supposed to do. And so what you have is inmate or workers who are responsible for whatever part of the execution they are responsible for, whether it is securing the inmate to the gurney, administering the IVs. You will find that there are some departments of corrections that they will have a medical personnel on staff to declare the person dead, but not necessarily to administer the drugs because it is against their oaths. So again, some differences that happen. Some do, some don't, but there are execution teams that carry out the official act of putting the inmate to death, and so we have to, and this takes a toll because while you are part of this team, you are carrying out the execution, you are putting someone to death. And so this takes an emotional toll. It's very stressful. And so you have to put that somewhere and deal with it later. And so that's also part of dealing with working on death row. And so that's the type of thing we have to be aware of. Inmates who live on death row typically are going to be one of 4 types of inmates. They are going to either state their innocence right through the execution, or they will completely focus on their legal work and ignore the fact that their execution date is coming up. They will turn to the religious side of things and completely dedicate their time there and adopt a new identity, completely transform into somebody who is different than what the person is that they came in with, or they will become severely depressed. And these are the people that will have troubles adjusting and might even attempt to take their own life while they are on death row. And so there are a lot of different anxieties and different types of responses that staff working on death row need to deal with. Whether it is the person who is still screaming that they're innocent to the person who attempts suicide while they are on death row and everything in between. And so therefore, the officer who has been assigned to death row needs to be aware of the different types of inmate that is in their working environment. The last part of this lecture, we're going to talk about the death penalty in general, the arguments for and against it, and whether it is an actual deterrent. Now we have 2 basic arguments against for the death penalty. If you are for the death penalty, then you are considered a retentionist. And if you are a retentionist, then you are mostly going to argue, number one, that it is a deterrent, that crime is a rational process, and therefore it only stands to reason that the possibility of a death sentence is going to deter those who are contemplating murder. If you are a retentionist, you are going to say that it is fair, that it is only fair that cold-blooded killers pay for their crimes with their own lives. And if you are a retentionist, you say that it is a threat of recidivism, that defenders of the death penalty charge that life imprisonment does not protect society because prisoners who have committed murder are usually eligible for parole after a period of time, or they commit murder while they are incarcerated. So those are what those people who believe in the death penalty say. If you are against the death penalty, then you are an abolitionist, and you oppose the death penalty based on, number one, a moral issue. That you reject the death penalty as a response to crime because that the argument makes the point that the majority of men and women have been African American or Hispanic that have been executed, in spite of the continuous attempts to build it into the judicial process. The second argument is that it's a constitutional issue. Challenges to the legitimacy of capital punishment continue by the ambiguous language of the 8th and 14th Amendments, and therefore continues that it is unconstitutional. If you are an abolitionist, you come up with the pragmatic issues, the possibility of errors, incompetence, or inexperience with defense counsels, police officers who are not truthful, or prosecutors who repress evidence. And they show the recent releases of those who were wrongly convicted as part of their argument. Another pragmatic issue is the costliness of the death penalty, which I have talked about in previous classes, but let's talk about the costliness of the death penalty. If you look at the totality of a death penalty case, and we're talking defense costs, court costs, and the actual stay, including in the prison, with security, and then the execution itself, we're talking a average cost to put somebody to death at about $3 million, because we're spreading this out over 20 years. Now you take that same 20 years and you have somebody who at 25 years old is sentenced to life in prison without parole. Now, life in prison without parole, I will generously give that person about 45 years. So at the age of 70, you have now put him in prison for 40 years-ish, and on average, the yearly stay, provided he doesn't have any medical costs or anything like that, is about $30,000 a year. So $30,000 a year times 40 years is about $1.2 million for his entire stay. $3 million to put somebody to death within 20 years, $1.2 million to have somebody stay in an institution for 40 years, and that's generous on a life without parole. That's a pragmatist view of why you should not have the death penalty. And so you have very passionate arguments between the retentionists and the abolitionists. And so when you think about it, let's look to the next slide and see, does the death penalty really deter murder? When we're looking at it, the defenders or retentionists of the death penalty claim that it's justified because of the incapacitation. You're dead, you can't commit murder anymore. But when we look at whether it actually is a deterrent, what we need to look at is empirical research. And so we look at things like immediate impact studies, time series analysis studies, and then contiguous state analysis. And if we look at immediate impact studies, this is what we use to try and calculate whether a well-publicized execution has on a short-term murder rate. And while that particular type of study really shows that there is no deterrent effect on the death penalty. In fact, immediate impact study shows that an execution really ends up with an uptick in the short-term murder rate. But when you look at time series analysis, or you look at contiguous state analysis, the rates there are more or less mixed. So what we have are the majority of researchers not being able to show any deterrent effect on the death penalty. And therefore, what we're finding is we have to do more research. And with the newer research, hopefully we can delve a little bit deeper and use a little bit more sophisticated data to uncover whether there's any significant association. And so with that, does the death penalty deter murder? Jury's still out. And so you can look at some and say yes, you can look at some and say no, and you can look at all of them and say we still need to do a lot more research to see if it does or not. And that is our lecture on the death penalty. And through it, we talked about the public opinion concerning the death penalty. We talked about aggravating versus mitigating circumstances concerning the death penalty and why that's important. We talked about the U.S. Supreme Court stance and several of the cases that they delved into when it concerned the death penalty, including race, mental impairment, juveniles. We talked about correctional officers working on death row and inmates and how they adjust to their situations. And we looked at whether the research out there shows that there really is any deterrence to the death penalty. Your discussion question this week is going to be to look at critical thinking question number 1 on page 364. Read it. Make sure you research. Use this lecture and the chapter to answer the questions in a minimum of 300 words. Make sure you cite in text in your answer, and when you are done with your answer, go to a classmate and dialogue with them about this, which is still such a hot topic in today's society. Well, thank you for your attention. Join me next week when we finish out this semester talking about the juvenile offender. Thank you.